In exceptional circumstances, I'm required to take time because the respondent number 12, this is the University Grant Commission, they filed an affidavit stating all lies in the petition. Therefore, my lord, it is required to controvert them. My lord, I want only 10 days time to reply.
It's the on request made by Mr. S. Dutta. Learned senior counsel for the petitioner. When do you want?
Just after 10 days. My lord.
After 2 weeks?
Yes.
List the matter after 2 weeks.
My lord, can your lordship fix a date?
You want a date?
Hmm.
2 weeks. 19th?
19, my lord, I'll be away. My lord, I'll be at Kohima bench.
When are you coming back?
My lord. On 22nd, my lord.
Okay. 22nd.
My lord, I think it will be marked as parted.
Yeah.
Much.
May page a lot. So the concern the other side, make you mention item number 26 a lot. Matter we adjourn for a day also. I am paying for a respondent here.
Kiman will
At 26.
how long?
Dutta, you're there?
Yes, my lord.
You
have to file the affidavit.
Counsel for the petition. On request made by Mr.
AI Ali, respond number 5, April.
Yeah, learned counsel for the respondent number 5. When do you want?
For 2 weeks.
List the matter after 2 weeks.
My lord.
Obliged.
My lord, I have another prayer, my lord, for item number 23, my lord. Here, my lord, what has happened in almost similar, my lord, identical prayers with identical prayers, the matter is pending in the Supreme Court, my lord. That's why the matter was being adjourned, my lord. That matter is yet to be disposed of in the Supreme Court. So my lord, that will come after, my lord, 6 weeks, my lord.
So that is along with 24.
No, 20, yes, my 24 is different, my lord. 24 is, my lord, by an individual, my lord.
But some.
Yes, my similar, my lord, related,
On request
related.
made by Dutta, learned counsel for the petitioner in PIL 27 of 2022. List the matter after 6 weeks.
My lord, diplomatic.
Yeah, please, my lord. My lord, may I mention item number 39, 40, 41. My lord.
39.
40, 41.
Yes.
What is the concept of the other?
Okay, on request made by the parties. When do you want?
11th of March.
List the matter on 11th of March.
Development. Meet please, your lordship. Lordship, in respect of item number 4, my lord, we raise some accommodation, my lord. In fact, my lord, the matter is led by an outside a lawyer, my lord. He's unable to appear today, my lord. That is that, my lord. My learned brother appears for the other party, my lord.
Yes,
My lord, may it be pass off for the day, my lord.
Okay, your good name, please.
H. Vitala, my lord.
Request made by H. Betala, learned counsel for the petition. When do you want?
My lord, after a week,
List the matter after 1 week.
deeply obliged.
Lordship,
Person is there on that. But
Okay.
then they say similar issues in here, but then Justice Barua found that it is challenge to the rule. I didn't realize that it is they are challenging the rule.
Lordship, item number 39 may be taken upon 11th of March along with item 39, 40, 41.
When do you want?
Item 39, Lord.
Yeah,
for
that
the-
is adjourned.
I'm for the response. No, sorry, 38. Lord. I'm for the respondents. Counsel for the petitioner, yes, some personal difficulty. Maybe taken on the 11th of March.
On request made by SC Learned. Lodi,
I'm for the respondent.
learned counsel for the respondents.
Petitioner has some personal difficulty, requested me to make.
When do you want?
On 11th of March, Lord.
11th of March.
Much up.
May I please, Your Lordship?
Mm.
We have filed a late petition, my lord, on 3rd of February, my lord. The matter will come up on Wednesday, my lord.
What?
Lordship. So it is surfacing matter already, a symbolic position has already been done. At any moment, they have taken position.
Okay.
Lordship, obliged.
May I please, lordship? I have similar prayer, lordship, for listing, lordship. Can it be on 9th, lordship?
Okay.
Lordship, I have also another prayer, lordship, for adjournment of item number 17, lordship. Lordship, in this matter, lordship, one additional affidavit is required to be filed, lordship. So, lordship, 2 weeks time may be granted, lordship.
Yeah, D. Boyan.
My lord, I'm D. Bhuyan, my
On
lord.
request made by D. Boyan, learned counsel for the appellant. List after 2 weeks.
Highly obliged, lordship.
Actually, I beg to mention item number 5, your lordship. This matter may be kindly fixed on 9th of Friday, your lord.
Your good name?
Judge Khalid, your lord.
Request made by that colleague, learned counsel for the petitioner, list on 9.
Yeah, please, your lordship. Lordship, I'm praying for listing of this contempt petition in the orders column, lordship. On Thursday or Friday, lordship.
Monday, 12.
One, oblate.
Item one for motion.
Please, your lordship.
Mm.
Lordship, with this regard to misappropriation of government fund, lordship. And in this lordship, this kindly come to page number 44, lordship. Here the RTI that has been filed by the petitioner, lordship. 44, lordship.
Yes.
Lordship, these are the queries that has been put by the petitioner, lordship. And page number 47 is the reply, lordship. Lordship, here, lordship, you can see, lordship can see, lordship, house in connection under Amguri TWSS 45 numbers. And house connection given under Sipsagar, lordship, Neil walk in progress, lordship. It is a scheme from 2007 to 2020, lordship. But at this point of time, lordship, nothing, no progress has been done, lordship. In this regard, the petitioner has submitted many representation, lordship. And kindly come to lordship 123, lordship, page number. Here, lordship, the additional deputy commissioner Sipsagar has issued a letter to the assistant commissioner Sipsagar to make an inquiry, lordship, and submit a report. That has not been done yet, lordship. Lordship, kindly, my simple prayer, lordship, to consider my representation and take legal action against this letter, lordship.
Against?
Against in connection with this letter, lordship, 16/6/23.
Is this?
Is number 123. We are hereby request to cause an inquiry into the matter and submit inquiry report to lordship. So no action has been taken in this regard, lordship.
Has anything happened after this, thus?
My lord, this is listed for the first time, my lord.
Second time.
First time it didn't appear, none appears. My lord, this with regard to this instruction is needed, my lord. Moreover, my lord, the main here is, my lord, respondent number 3, Assam Urban.
No, but whatever it is, you get some instruction on this.
Yes, my lord. I can, my lord.
But MSM Nirola, learned counsel for the petitioner. Stop Mr. Endas, learned additional
No, government advisor.
government advocate shall take instructions with regard to the outcome of the letter dated 16/6/2023 within bracket annexure M to the present PI. Stop. List when?
But 3 weeks, my lord.
Why 3 weeks? We'll have it after 2 weeks. List on 19th.
My lord, 18th,
19th.
19th.
Item 2 and 3.
May it please your lordship. Lordship, this writ petition has been preferred by the Union of India, lordship, challenging the order dated 2/6/23 by which the Land Tribunal allowed the OA, accepting the claim of the respondent, for which they claim the great pay of 4,600 with effect from 1106. Next, the next great pay of 4,800 from 1908 and 5,400 from after grant of second MSCP, lordship. Now, our main contention, lordship, the ground are that, lordship, the service rule says that will find, lordship, at page. Service rule start from, lordship, page 141. And the pay scale that has been, lordship, will find it page 159, schedule. What has been fixed from the post of junior translator and senior translator? Lordship will find in serial number 5 and 6. The grade pay has been stated for senior translator is 4,600 and the junior translator is 4,200. Here the tribunal allowed the grade for junior 4,600 And for the senior, 5,400. Next, Lordship will find the advertisement issued by the Staff Selection Commission, page 173, Lordship.
Yes,
Lordship, this junior translator, Lordship, serial number A, their entry level is level 6, and the senior is an entry level 7, that is E. Now, this is corresponding to the parametrics, Lordship, 4,200 and 4,600. And the last contention is, Lordship, the MSCP scheme, under MSCP scheme, Lordship, page 129. 129.
yes,
Point number 5, Lordship. The promotion earned upgradation granted under the SAP scheme in the past to those grades which now carry the same grade pay due to merger of pay scale and upgradation of post recommended by the 6th Pay Commission shall be ignored. Now, this point has not been considered, Lordship. Moreover, Lordship, the Department of Expenditure has given a clarification that will Lordship find at page 136. We are bound to follow, Lordship, Ministry of Finance, Department of Expenditure, Lordship. And they have prescribed the grade pay as page 139 and 140. 139 deals with the Lordship senior Hindi translator. They stated that grade pay should be 4,600. And the next page 140, senior translator, Lordship, the grade pay should be 4,200, Lordship. So our contention is that this is an executive function. I'm relying on this decisions, Lordship. Or should not and tribal delve into. Matter of prescribing what pay scales should be given are matter to be done by the executive. It's their prerogative. Court should not delve into. So matter will need examination. At this stage, notice maybe should let them file their response, Lordship.
yes.
2009 1 SCC, page 73, para number 16, Lordship. May I read, Lordship?
2000,
2009 1 SCC, paragraph number, page 73, para 16. The first one has not been marked because that is from 2 onwards, it has been marked. First one, Lordship, is the second page of my compilation. Paragraph number 16, may I read, Lordship? The question as to whether the scale of pay would be revised or not is a matter of policy decision of the state. No legal right exists in a person to get a revised scale of pay implemented. It may be recommended by a body, but ultimately it has to be accepted by the employer or by the state, which has to be bear the financial burden. Lordship, the second one is, Lordship, 2002 6 SCC, page 72. And the relevant paragraph is, Lordship, 10, Lordship. 9 and 10, Lordship. May just read 10. The concluding part, Lordship. It has to be kept in mind that the claim of equal pay is not a fundamental right vested in an employee, though it is a constituent goal to be achieved. Fixation of pay and determination of a parity in duties and responsibilities is a complex matter which is for the executive to discharge. While taking a decision in the matter, several relevant factors, some of which has been noted by the court in the decided, are to be considered, keeping view of the prevailing financial position and capacity of the state government to bear the additional liability of a revised scale of pay. It has also to be kept in mind that the priority given to a different types of posts under the prevailing policies of the state government is also a relevant factor for consideration by the state government. In the context of complex nature of issues involved, the far-reaching consequences of a decision in the matter and its impact on the administration of the state court have to be taken the view that ordinary courts should not try to delve deep into administrative decisions pertaining to pay fixation and pay parity. So, Lordship will examine this at this stage. Notice may be issued.
Clearly, sir. Wherein, my lord, actually issue is already settled. Similarly situated employees earlier approached before the Ernakulam bench, my lord. OIO was allowed. Against that, Union of India has preferred an petition before the Kerala High Court. That was dismissed. Accordingly, against that order, they have preferred an SLP. Honorable Supreme Court allowed them, my lord, that upheld the judgment passed by the learned Ernakulam bench. For that, my lord, I am placing the judgment.
No, we'll issue notice and we'll consider the matter. Not today.
Delhi High Court has taken different to have annexed that order, annexed at 12, Lordship. Lordship will at this stage issue notice.
You have filed a caveat?
Yes, he filed caveat, Lordship.
Yes,
Caveat is they heard M. Chanda, Leonard Counsel.
Yes,
for the
Chaudhary.
caveat.
yes, Chaudhary.
S. Chaudhary, Leonard Counsel for the caveat. Now the caveat stands discharged. The suit appeals,
Writ petitions, Lordship.
petition 160. Heard Mr. B. Chakraborty and Siloji for the petitioners. Issue notice. You are appealing on behalf of all the respondents?
Lordship.
First one is two respondents,
Yes.
second one is single, one, only one.
All the rest.
Both the respondents?
Yes.
Mr. S. Chakraborty, Leonard Counsel.
Chaudhary.
Chaudhary and enters appearance on behalf of the respondents 1 and 2. Stop. It's after 2 weeks. List the matter after 2 weeks.
Same order in three, only the case number is different. Common order has
Same,
been,
same.
common
Common
order.
Same order. Different order.
Deeply obliged.
Item 45 from supplementary list.
Meet with the lodge. But in this case, my lord, the notice under 13(2) of the SARFAESI Act has been issued. And my lord, the most obvious part is that this has been issued among others to a dead person. Lordship will kindly come to my lord's 133, page 133, my lords. That is the notice, it is dated 10/11/2023, my lord.
133.
Yes, my annexure 9. my lord.
Yes.
Well, Lordships will find that this notice has been issued to as many as 8 persons, my lord. And the addressee number 2, that is Om Prakash Bajaj, my lord, and he has passed away in 2020. Now, the bank is also aware of this, my lord. Lordship will kindly come to page 155. my lord. Lord, Annexure 12, page 155, my lord. This is the death certificate, my lords, of Om Prakash Bajaj, my lord, who was one of the partners of the firm. This is, my lord, he passed away, my lord, on 19/1/2020. And the demand notice is issued on 10th of November 2023. And why I am saying, my lord, that the bank is otherwise fully aware is that, my lord, this account has been there since, my lord, 2019. Every year it is renewed. So when it is renewed, my lord, then all the details, including partnership deed, copies, etc., everything is, and the partnership was reconstituted. My lord, the reconstituted partnership deed also have annexed, my lord. And that, my lord, is at page 21A. my lord. The partnership was reconstituted immediately after the passing away of Om Prakash Bajaj, my lord. The deed starts at 21A, my lord, annexure 1.
Page
Yes,
21.
21A and 22, my lords, is the name of the continuing partners, my lord. One, Rajesh Kumar Bajaj, Sanjay Bajaj, Ritika, Rishabh, mascot entered, incoming partner, Srimati Draupadi Devi Bajaj, and retiring partner, late Om Prakash Bajaj, so and so. And my lords, it is quite clearly mentioned here that this was after the death of my lord. The lordships will just have a couple of paras below, my lord, this part, and whereas due to the death of my lord, that part. Whereas due to the death of late Om Prakash Bajaj became deceased retiring partner, and on his place is legal heir Srimati Draupadi Devi Bajaj. His wife is being admitted and continued from the day of January the 20th, 2020. And my lords, each and every notice thereafter
my lords, the bank is aware that this person has passed away. And in fact, my lords, at page 55, lordships will find that there is a communication, in fact, was sent just before the account was declared as NPA. Lordships will find page 55, that is annexure 7. This is the so-called final reminder. Lordships will find the name of 6 partners of the firm are mentioned, including the name of Srimati Draupadi Devi Bajaj, and the name of Om Prakash Bajaj is missing from here. On the face of it, the 13-2 notice is liable to be struck down. There are other issues, so at this stage, lordships will kindly stay the further coercive action because this notice on the face of it is null and void. But let the bank come and respond because what has happened in the meantime is that since November, they have blocked my only current account. Now, without a current account, a factory which has a transaction of almost 2 crore rupees a month, I am unable to. How can they close the business, close the account, and then expect me to pay the dues? This is a running concern. It is not a factory which has closed down or which has no viable means. They have apart from wrongly declaring the accounts as NPA, which is a separate issue altogether, they have blocked my only current account. And there is a specific stipulation in the sanction letters of the bank that I cannot operate any current account with any other bank. If I do so, they will levy 2% additional interest. Lordships will kindly have for a moment the sanction letter. At page 34, if your lordship, for a minute. This is the last renewal sanction letter, because these loans are renewed every year. So documentation occurs 30th of March 2023. Lordships will find at page 36, if I may take your lordships to me. This is clause number 11, other covenants. Now, if your lordships come to the para E below, additional interest levy, this part, lordship will find that additional interest levy at the rate of 2% per annum, additional interest levy over existing rate of interest on account of 1. Maintaining current account with other bank while facility is granted under sole banking, applicable where specific permission is not taken by the commission by the customer. So, my lord, this specific permission is never given unless this is a case of the consortium banking, which means that more than one bank is involved. So,
Where's the notice?
my lord, notice is at page 133, 133. Lordships will at this stage issue notice, my lord, and stay the further course of action.
Mr. Ganguly, done a consult petitions. Stop. Issue notices. Who appears for union? Mr. RTB Dev Chowdhury, Leonard. Deputy Solicitor General of India appears for the respondent number 1 only? Only 1. So petitioner to take steps for service of notice on the respondents 2 and 3 by registered post AD.
No, to my knowledge, 2 is represented by a standing counsel, I believe, Reserve Bank.
So you take steps
I'll take.
by within 1 week from today.
Lordship.
Next 4 weeks. Till the next returnable date, no coercive steps be taken against the petitions.
Lordships will say kindly pursuant to the notice that demand notice dated.
No coercive steps shall be taken against the petitioner. Pursuant to the demand notice.
Yes, demand notice dated 10/11/2023.
10/11/2023. Issued by the
Follows the respond number 3 bank.
issued by the Respond number 3.
Deeply applied.
Order item 46 for admission.
So on the last occasion, my lord, I concluded my part. The respondents are supposed to argue, and thereafter, my lord, if required, my lord, I'll reply. My lord.
With your lordship.
Yes.
My lord, I'd like to take your lordship to the order, my lord, dated 24 July 2023 at page 37, my lord. This was the transfer order that was passed. Page 37 of the. Your lordship will kindly see, in the interest of public service, the governor of Arunachal Pradesh is pleased to order the transfer and posting of following executive engineers under Arunachal Pradesh Public Works Department in the places shown against it with immediate effect. My lord, the first, Bhage Tajang, and then the appellant, my lord, Ponpang Sangha. Your lordship will see, this is a plain and simple, my lord, regular nature of the transfer. The incumbents had crossed the period that is allowed, after which they can be transferred, my lord. I'll come to the notification, my lord. The purpose is to help the particular officer or the employee, so that before retirement, my lord, they get nearer to the capital where the headquarters are, and where, my lord, because these are field posting, my lord, at the border, my lord, Longding, your lordship is aware, my lord. So the purpose of the notification is that, my lord, there may be, my lord, 2 weeks here or a couple of weeks, my lord, later than that exact 1 year period, my lord, which is not possible, my lord, in administrative exigencies, my lord. So, my lord, my purpose is say that he was regularly transferred, my lord. The issue of that, my lord, propagating religion or that has got nothing to do with it, my. And he was not transferred, my lord, on his own, my lord. He was transferred against somebody else, my lord, who had come, my. In my affidavit, my lord, my reply is there, at specifically at para 5, para 6, and para 8. This is the affidavit filed by the Undersecretary of the department concerned, my lord. Para 5, my lord. Before that, my lord, para 4, just one line, my lord. Para 4, my lord, I'd like to read it. Page 66 on the running page. That the deponent begs to state that the appellant is transferred from Longding to Chief Engineer Itanagar in the interest of public service and administrative convenience by government order number so and so dated 19/7, which was issued on 24/7. As per Department of Personnel Circular number so and so, the 1D, the officer is not to be transferred 1 year before retirement, as it may affect preparation of their pension papers, etc. However, your lordship will kindly mark this. However, generally officers posted in field work divisions should be posted out to office headquarters 1 year before retirement. Hence, the appellant was transferred to headquarter office, which is located in the vicinity of the office of the Director, Audit and Pension, where pension matters of retiring government servants are dealt. As such, it is reiterated that the appellant's transfer to headquarter would rather facilitate him in preparation submission of his pension papers for timely release of pensionary benefits after his retirement through the headquarter office in Itanagar. Though Itanagar runs for the kilometer Longding, locations are well connected with highways, and the appellant can reach his new place of posting in 7-8 hours by state. Then 5, my lord, this is the my lord, with respect to the that allegations, but since that allegation is not connected to this, my lord, so therefore, my lord, this is not necessary, my lord. For the
Why
time
have you stated it in your affidavit?
My lord,
Why did you state it in your affidavit?
no, my lord, this was in reply to their application, my lord. So that is why it has come. Our orders are devoid of any of these reasons, my lord. And public order, my lord, in public interest, my lord, must be taken as granted, my lord. We have stated here also, so there was administrative action as per him. And my lord, your lordship will kindly come to my lord. He had alleged, my lord, in his pleadings, my lord, that my lord, the person who has been transferred to Longding belongs to Longding, my lord. That was his, so far as my lord, the pleadings on Malafide, my lord. That he was there, so he was brought, my lord, through vested interest, my lord, which were denied in para 6, my lord. That the deponent further begs to state that the private respondent belongs to Lower Subansiri district, page 69, and Longding is not his native place as claimed by the appellant. Hence, the appellants claim that the transfer was done to accommodate the private respondent. The native place of private respondent is false and untenable. So that allegation also goes, my lord. In fact, my lord, this is a gesture, my lord, of seeking to help him by sending to the headquarters, which the competent authority did. And that has been misinterpreted, if I may submit. And my lord, my friend has said, my lord, this is less than 1 year. My lord, had 20 days less than 1 year. 20 days. My lord, these sort of things, my lord, we cannot exactly 1 year or my lord, that cannot be done, my lord, in my humble submission. Sometimes it may be a couple of weeks here and there, my lord, maybe prior to that or later than the period. But the purpose is to help the officer concerned. That is why he was sent there, to the headquarters. Now we are facing a problem because, my lord, even if we are putting, my lord, the private respondent in another placement, that is a temporary arrangement, my lord, for during the pendency of this case. And pursuant to lordship's reactions, we have been paying him also, but that is not regular posting. This had to be done because of the interim order granted by this court. And lastly, my lord, my friend had placed reliance on that, my lord, 2009, my lord, Somesh Tiwari's case. Well, that case, my lord, it is on Malafide. It clearly says, my lord, Somesh Tiwari's case, they held that the transfer, which is ordinarily an incidence of service, should not be interfered with unless Malafides are attributed to the authority. Passing that order is proved. That has to be proved, man. Well, here in fact, no one has been, my lord, impleaded here. If he is trying to say something against the authority, no one has been named, my lord. If somebody is the respondent is impleaded, my lord, he is only the official capacity, not in person, man. And the other allegation that we are trying to help the private respondent by bringing him to Longding, which is place, that is without any basis. The issue relating to, my lord, that propagating and whatever, that is a different thing, my lord. My lord, maybe, my lord, he can propagate anything, but he cannot use the name of the department, man. How can he use the name of the PWD? But even then, since he is retiring, we have not, my lord, resorted to any proceedings. Since he has removed the signs, man. But the transfer is, my lord, independent of all these things, my lord. He has completed 2 years service in Longding, my lord. He joined there in 21. And he has been transferred against the private respondent. That is the humble submission.
Made to the lordships, my lord. The lordship is marked, my lord, the transfer order at page 19 of the IA. My lord, there was only 90 days short of 1 year in his transfer because he retiring in June 30th. And he was transferred on, my lord, 19/7/2023. Only 90 days short, 19 days. Well, that would not make any difference, my lord. Secondly, my lord, also the respondent 3, I am appealing for the respondent 3, private respondent, my lord. He on the transfer, he was twice transferred earlier. He joined, my lord, on 27/7/2023. And took he joining report was submitted at Longding, and he took charge unilaterally because the other side was not giving the charge. There is a circular matter of 2007. One can take unilateral charge that he has taken in Easter functioning. But suddenly again he came and forcefully threw him out and sat on the chair. Against that I reported to the government. And I am still there. He is neither functioning nor allowing me to function. So it is standstill. The office is, my lord, almost defunct. Now we'll also kindly come to the circular dated 2/6/1998. There are two conditions while on transfer. One is generally one officer should not be transferred, my lord, after 1 year. And second is, my lord, that generally one should be transferred before 1 year to the headquarters where his, my lord, pencil papers may be ready for disbursement immediately on his retirement. So considering that aspect of the matter, my lord, though he had committed some misconduct in particular religion, whatever religion it is, my lord, in the name of the PWD department, the lordship see my page 89 and 90, yet the government seems to be very considerate because of his due retirement after 1 year. So, my lord, in that respect, malafide has to be proved. That's one thing, my lord, Mr. Tiwari. And, my lord, I'm also relying on the decision of the apex court, my lord, this Shilpi Bose case. It's a famous case, my lord. What after there are a number of other decisions. Didi. Dear my lord, the transfer order of the respondent here, the private respondent was put under challenge by him, and the other side affected person went to my lord, Supreme Court against the order of the High Court, my lord, and ultimately the appeal was allowed and the transfer order was upheld and the decision of the High Court was set aside by the Supreme Court, my lord. Paragraph 4 is the my lord, core of the issue on transfer. In our opinion, the court should not interfere with the transfer order which is made in public interest and for administrative convenience, administrative reasons, unless the transfer orders are made in violation of any, my lord, mandatory statutory rules or on ground of malafide. So unless it is, my lord, on violation of issue rules or malafide. Malafide is not easy to prove, my lord. Malafide, in case of malafide, the party against whom malafide is alleged, suppose the respondent passing the transfer order should be made party and bring strong allegations are malified against him. Other there are other decisions of Supreme Court Malad where malified has to be malice in law and malice in fact is to prove. Definitely, my lord, to get the relief in a writ court because it is a court of equity. So, my lord, based on this, my humble prayer is, my lord, that the appeal should be dismissed and, my lord, the stay order should be vacated. And since I have already joined, the fact is incomplete, my lord. The order of transfer is complied. I have taken over charge. So now nothing to interfere. And moreover, he is going to headquarter, my lord. Let him prepare the, my lord, pencil papers and submit. Government is quite considerate in that respect. If, my lord, your lordship has marked that on the basis of 1998 circular, my lord. 1990, page 42. Page 42 of the read, Annexure B. Page 42. Just a minute. Officers are not to be transferred 1 year before retirement, as it may affect the preparation of the pension papers, etc. So, my lord, what was the consideration why one should be transferred before 1 year of the should not transfer before 1 year because it may affect his pension paper. So here, since he is being transferred to headquarters, to easy the preparation of the pension papers. Secondly, my lord, however, generally officers posted in the field, he is posted in the field, work divisions should be posted out to office headquarters 1 year before retirement. 1 year is 19 days short. So, my lord, how it affects, and it is circular only. The Supreme Court decision is, my lord, the authority. There is no malified, and malified is then proved. The party making it is not made party, my lord, making the transfer order. And, my lord, he was also arguing, my lord, on my lord, para F of the same circular. Any officer against whom there are serious complaints should be proceeded against the department since transfer shifts the evil from a area to another, thereby affecting the interest, affecting the interest of the people to whom and is in. So his plea was, my lord, that he should have been proceeded departmentally. Then he would support that he would not get pension until the department proceeding were decided. Does he want that? Certainly not. Once the proceeding is initiated against him for the allegations, any officer, then, my lord, it will be 3-4 years since the department proceeding will end, and then only pension will be cleared. So, my humble submission, my lord, there is nothing to interfere. Already your lordship is on the facts of the case. My learned friend on the other side, he has already put everything before your lordships. And since the transfer order simplicity, my lord, not tinged with or not colored with any malified or malice, so it need not be interfered. And already, since the matter is even already completed in a sense, he has already joined. The responsibility has joined, taken over union charge, and he is there since last 6 months. And there, my lord, there is one circular of the government, another Pradesh, my lord, where unilateral charge can be taken by an officer who is not allowed to take charge or who is not handed over the charge with. There is, my lord, 13th of February 2007 circular, my lord, para 4. That is in my IA, my lord, page number 27. In IA, my lord, IA number 228 of 2000, sorry, 3234 of 2023. So I've complied with the government circular, my lord, took over charge,
Page
page 27, my lord. Para 4, my lord. So I'm on this one. So decide, relying on the Supreme Court decision, City Boss, my lord, the famous case, as always the facts of the case. And my lord, that there is no parameter, my lord, there is no measuring scale that it should be exactly 365 days, one should be transferred. It is only 19 days, sir, my lord, of 1 year. And government exigency, your lordship, my lord, government files generally move very slow. So the decision might be taken long back, but while the communication of the order came after 19 days. So in that way, the matter, there is nothing to interfere, since the transport is not nullified. It is as per the rules, and since I have already taken up charge, and I am there since last 6 months. That's all, my lord. And he is, my lord, my client, my lord, responsibility is brought the children here, and my lord, bag and baggage, lock, stone, barrel, he has come and already settled in Longding, my lord. So to dislodge him again, my lord, will be it. There is an inconvenience on his part and for his domestic peace. Oblige, my lord.
Lord, in reply, I'll just clarify 2-3 points, my lord. The submission has been made by the Learned Council for the government of Arunachal Pradesh, my senior, that the allegations are unconnected to the transfer, my lord. And if I take your lordships to para 5 of their affidavit, page 67, if I may read 2 lines, my lord. Firstly, it says that a legal notice came from Maharashtra, then that was communicated to me. If your lordships kindly take para 5, my lord. Lord, in between, my lord, down below, such act of appellant, your lordship will get. Lordship, my lord. Such act of appellant, being a government servant, could create no law and order situation created, could create law and order situation in the district, and his continuance in the district may not be appropriate for containing law and order and for smooth administration of the district. So, there was administrative exigency to transfer out him from the district in the interest of public service, administrative convenience in the district, and to avert further misuse of government fund. So that allegation was the foundation to transfer him out. in their affidavit, from their affidavit, it is apparent that on the basis of those allegations, he was transferred out. And it is a clear case of punitive transfer. In the next page also, if your lordships kindly take, by referring to my reply, they say it was admitted by the appellant that the signposts were erected in his own expenditure and no government funds were used for the same. The said admission itself go to show which is unbecoming of a government servant. But I admitted that I erected by my own expenditure. How that admission can lead to an unbecoming of a government servant, and they have taken it to be an unbecoming of a government servant. My lord, one judgment of our Honorable High Court, my lord, absolutely identical facts. I'll just place. Here also, my lord, there were complaints made against the teacher and he was transferred. And what this Honorable Court has held, my lord. Para 11 onwards, your lordship would get the facts as well as the ratio also, my lord. How the Somesh Tiwari has been appreciated by this Honorable Court, my lord.
Yeah, single bench.
Single bench, my lord. I'm just to persuade your lordships, my lord. I'm not saying that this is binding upon your lordships. How Somesh Tiwari was evolved in an identical factual situation. I'll just place it. Para 11, it appears from the aforesaid judgment that although unsatisfactory performance formed the basis for transfer, which also involves certain subjective opinions, the impugn order of transfer was not considered to be illegal or arbitrary. The formation of the opinion was on the premises that the petitioner therein was not transferred solely on the basis of certain complaints. In fact, a procedure was adopted to verify the allegations through an officer who in turn submitted a report, and it was only thereafter on formation of an opinion the impugn action was resorted to. In the instant case, no such procedure was adopted to verify the allegations made in the complaint against the present petitioner, nor the order of transfer was resorted to on the basis of any report submitted by any subordinate authority. In that view of the matter, the judgments relied upon by Sri So-and-so does not come into the aid of the respondents. Now, para 13, para 12, my lord, the law laid down by the Somesh Tiwari was discussed. Then para 13, my lord. Applying the ratio laid down in the case of Somesh Tiwari, there is no gainsaying that the basis of transfer of the petitioner to another school was on the allegations made against him in the written complaint filed by the SMDC authority. Indisputably, the order of transfer was not issued on administrative exigency, which may have prompted this court to shy away from interfering with it. Malice in law on the part of the authority in issuing the order of transfer is writ large, and situated thus, the order of transfer is liable to be set aside. The order of transfer dated so-and-so being issued on the allegations made against the petitioner, which attracts the principles of malice in law, is not sustainable in law and accordingly set aside. As a necessary corollary, the action of the state respondents in withholding the salary of the petitioner, so-and-so, is wholly unjust. The contention of the state respondents that the petitioner is not entitled to pay for the dates for which he did not attend duties is too far-fetched a proposition in attending facts and circumstances of the case. To uphold the stand of the respondent would certainly amount to allowing the respondent to take undue advantage of its own wrong. More so, when this court have found that the order of transfer was wholly illegal. In the circumstances, a direction is to made to the respondent authority for payment of salary of the petitioner for the period from so-and-so to so-and-so. So, if a complaint has been made, you are to derive an objective satisfaction, even there is a complaint. you have to make an inquiry whether the allegations here, my lord, a email came from Bombay and that email some allegations made. I categorically denied those allegations, and there was nothing before the respondent that I spend government money for those erecting those road signs, and they transferred me. So, and they also say that it is a clear case of misconduct. In that view of the matter, my lord, it's a clear case of punitive transfer. And so far as my right under Article 25 of the Constitution of India with regard to, my lord, religion, that in that context, my lord, two judgments I have brought before your lordships for your lordships consideration. I'll not read it, my lord. Lordship will kindly, I'll just mark the paragraph, my lord. In 71, 77, 1 HSC, 677. My lord, 1986, 3 SCC 615.
Yes.
Lordship will kindly come to page 617. I am not taking your lordships to the entire paragraph. I am just the relevant portions, my lord, I am taking. Page 617, there is one serial number 4, my lord. In this case, my lord, the students, my lord, they, students of a school, they refused to sing the national anthem, although they stood up. In that context, Article 25 was appreciated. The impugn action also violates Article 25. While interpreting this article, it must be borne in mind that Article 25 is an article of faith in the Constitution, incorporated in recognition of the principle that real test of true democracy is the ability of even an insignificant minority to find its identity under the country's constitution. It is the duty and function of the court, whenever the fundamental right under Article 25 is invoked, to examine the act and to see if it is to protect public order, morality, and health, or whether it gives effect to the other provisions of Part 3 of the Constitution, or whether it is authorized by a law made to regulate or restrict any economic, financial, political, or secular welfare and reform. The purpose of legislation in question may properly be taken into account in determining whether or not it is a law of the prohibited character. An action validly restricting the right under Article 25 must, however, be based on law having statutory force, not on mere executive or departmental instructions. In deciding whether Article 25 is attractive in a particular situation, the question before the court is not whether a particular religious belief or practice appeals to its reason or sentiment, but whether the belief is genuinely or conscientiously held as part of the profession or practice of religion. The personal views and reactions of the court are irrelevant. Now, the other judgments that I am relying on, the lordship, the relevant paragraph is
Which judgment?
that I'm sorry, my lord, 1977 1 SCC 677, my lord. Para 21, my lord. The purport of Article 25 has been, my lord, discussed here, para 21. The meaning of guarantee under Article 25 of the Constitution came up for consideration in this court in so-and-so, and it was held as follows. Thus, the subject to the restrictions which this article imposes, every person has a fundamental right under our constitution not merely to entertain such religious belief as may be approved by his judgment or conscience, but to exhibit his belief and ideas in such overt acts as are enjoined and sanctioned by his religion, and further to propagate his religious views for the edification of others. This court has given the correct meaning of the article, and we don't find justification for a view that it grants a fundamental right to convert persons to one's own religion. It has to be appreciated that the freedom of religion enshrined in article is not guaranteed in respect of one religion only, but covers all religions alike. And it can be properly enjoyed by a person if he exercises his right in a manner commensurate with the like freedom of persons following the other religion. What is freedom to be? No such thing as a fundamental right to convert any person to one's own religion. So, in the respondents, in many words, tried to say that I am propagating my religion. I am entitled under Article 25 to propagate my religion. I did not convert anybody, Milo. There was no material before this honorable court or has been brought by respondents that I was involved in converting person. I am entitled to propagate my religion under Article 25. And the name of the department has been given in those road signs. Lord, if I haven't spent the official money for that, I have done that from my own money. Lord, how any loss or reputation of the department has been put at stake, Milord? It cannot be the case of the government of Arunachal Pradesh that, Milord, they don't promote any particular religion, Milord. State is secular for all, Milord. So even then also, Milord, there was no fault on my part, although they have taken it to be a fault and passed the transfer order. And the judgment relied on my senior, that is Silpi Bose and others, state of Bihar. You know, this judgment is factually distinguishable, Milord. Here, Milord, the issue was on request to avoid hardship challenged by affected employee, lady teacher of primary school in Bihar. She made a request transfer, Milord, to the place of posting of her husband. And in that context, the Honorable Apex Court has said, Lordship is aware that, Milord, the ratio of the decision becomes a binding precedent on the basis of facts and the regions assigned therein. So a little difference in facts, Milord, lead to a different conclusion. Here the facts are totally different, Milord. Here the facts are, firstly, they violated that clause D. We came before this court. This honorable court stayed the transfer order, and I continued from the date of passing of the stay order, Milord. I continued. Till date, I am continuing. And from their affidavit, it came that F was also violated, Milord. Clause F was also violated, and it's a clear case of punitive transfer, Milord. So in my humble submission, Milord, one more thing, Milord, I'll just like to point out. In the affidavit in opposition file to file in the IA, Milord, submission has been made by the government that the private respondent, Milord, he is on a temporary post. Milord, this order clearly shows page 48 of IA affidavit in opposition. He was posted against an existing vacancy, Milord. The private respondent, he has been accommodated against a existing vacancy in another place, Milord. So he is no way aggrieved. His salary has also been released, Milord. He is no way aggrieved now. Page 48, annexure P2, my lord. Of the affidavit in opposition. Running page 40. Running page 48, my lord. Of IA, my lord. Lord, you will find it in the IA.
Yes.
Yes. Sri so-and-so to this office against existing vacancy, and his pay and allowances shall be drawn with effect from so-and-so. Subsequently, my lord, his pay and allowances were released, my lord. So in my humble submission, my lord, this transfer order, my lord, is absolutely punitive in nature. And that was the motive and foundation for issuing the transfer order. And the appellant, my lord, he is retiring in the month of June. So, my lord, hardly around 4 or 5 months left, my lord, 4 months left. So, in my humble submission, my lord, this appeal deserves to be allowed, my lord, interfering with the transfer order and allowing the petitioner to appellant to continue this 4-month service in his at Longding, my lord, till the date of his retirement. That is my submission. Deeply object.
My lord, since he is bringing a new arguments now, my lord. Way back in 1958, my lord, there is a circular by the government of India, from India, it is applicable to India. That sees the country's secular, my lord, very principle says, any propagation of any religion by government servant or participating in any such program is prohibited. I've got a circular, 1958 circular. And my lord, moreover, there is an act, his lordship's Kardak may know it. There is one act of 1978, my lord, when it was Union Territory, then Government of India issued, passed the act in Parliament, my lord, that since Arunachal, earlier known as Nepal, is very secluded and very backward area, and they have got their own indigenous religion, my lord, Doni, Polo, and other religions. So they are to be protected. So neither the even propagation of Hindu Dharma or Saivite or Vaishnava Dharma was prohibited by the act. Nobody, no religion would be propagated in any way, either by the government itself. Government is far beyond, even by the private individual. Suppose I am a priest, I cannot go and suppose I am a Hindu priest, I cannot go and propagate even Saivite. That is prohibited by 1970 Act, passed by the Parliament. So, my lord, the government is not going on that. Government is simply simplifying the matter without anything, without any punishment, without punitive action, and even not bringing allegation against him, as such in the transfer order, my lord. And if he wants to prove the malified, then he must make the party in the order to be malified. Should I hand over the mind of that circular of 1958? Because he is covered under the thesis conduct rules. So,
That is beyond treatment.
it is prohibited.
That is
So,
beyond.
my lord, in that view, the writ appeal should be dismissed, along with the writ petition, and the transfer order should be vacated. And
It has that counsel for the appellant.
safety post cases, my lord, the principle is set.
Also had Vidya Das, Learned Additional Advocate General Arunachal Pradesh. Sorry.
D. Goswami.
I am R.P. Sharma, my lord.
Waiting for the respondents, 1 and 2. And then
My lord, may I leave the court, my lord? Another call is there.
R.P. Sharma, Learned Senior Counsel, assisted by
By Saurabh Dhingia, yes, Dhingia.
S. Dingia for the respond number 2. Hearing concluded, judgment may not.
Deeply obliged. Much obliged. But in this matter, Arunachal, Nagaland and Mizoram is yet to file their affidavit. Government of Assam has filed their affidavit. So this is with regard to, my lord, modernization of the facilities. That is, my lord, e-prison app, development of e-prison app and real-time integration with the jail authority.
Nagaland and Mizoram.
I am appearing for Mizoram Lordship. I pray some time, Lordship.
Nagaland.
4 weeks time. 4 weeks time, Lordship.
I am appearing for state of Arunachal Pradesh Lordship.
Hmm.
Same Lordship, 3 weeks time for it.
Okay, heard H.K. Das, London Standing Council, Guwahati High Court. MS Pichi, Learned Advocate General Nagaland, comma. MS
P. Bhattacharjee, Additional Advocate General, Mizoram.
P. Bhattacharjee, Additional Advocate General, Mizoram.
Yep.
And Mr.
A. Chandran Lordship.
A. Chandra, Leonard,
Chandran, additional senior GL.
additional senior J for the state of Arunachal Pradesh are all allowed 4 weeks time to file the respective affidavits.
Lordship.
Next after 4 weeks. MS R. Barwal, Leonard Council appears on behalf of on behalf of the cycle AG for the state of Assam.
Apply.
BPO.
My lord, we have to file an affidavit, my lord, in this matter. I pray for 2 weeks time, my lord. I'm appearing on behalf of Mr. P. Naik, my lord, Standing Council SSC.
Okay, yes. Heard, Mr.
Yes, Rana.
Yes, Rana, the council for petition. Ms. R. Barwa. Leonard Council appearing on behalf of Mr. P. Nayak. Leonard Standing Council SSC
SSC, my lord.
is allowed how much time?
My lord, 2 weeks, my lord.
No, 3 weeks time to file affidavit. Please after 3 weeks.
Right.
Yes.
My lord, can this matter kindly be passed over for the time being? Mr. S. Bothakur will appear, my lord. Much obliged.
My lord, in this case, I have not received the proper instruction. I have received some instruction, but it is not adequate, my lord. That is why, my lordship may kindly give me 2 weeks more time, so that, my lord, I can take the instruction in the core issue of, my lord, regarding appointment of local person and as per the 6th schedule of the Constitution, as per the recommendation of our Honorable Justice Vacation. That is the issue raised in this pair for implementation.
Then
Lordship may fix a date in the.
After 2 weeks.
okay, heard, Mr.
Is there, my lord?
Yes, then and a counsel for the petition. Mr. D.K. Sharma and an additional senior government advocate is allowed how much time?
After 2 weeks, in it
Is allowed 2 weeks time to file affidavit,
take inspection.
to receive instructions. List on 1, 2 weeks. 21st February.
Published.
Much obliged.
Item 10.
May it please your lordship. Lordship may kindly pass over the matter for a day as my senior had some personal difficulties.
Item 10.
Yes, my lord.
Okay, on request made on behalf of Mr. B.D. Conward and the senior counsel.
What did he?
For the petition. When do you want? List up to 1 week?
Lordship, any dates,
List
please.
after a week.
What?
11.
Same order, my lord.
Okay, on request made on behalf of Mr. B.T. Conward, then is amicus curiae. List after 1.
Much obliged.
12.
I am appearing for the respondent. Appeal has already been admitted. May come for hearing, lord.
This has been admitted.
Yes, admitted and substantial question of law has been framed.
No, it has not been admitted.
I'm for the respondent.
Mm. Mm.
Can we come up for admission? Some other day? The counsel for the appellant is not there.
Okay, none appears for the appellant. Mr. Ezekiel and a senior standing counsel. Income tax department appears for the sole respondent. Please, after 1 week.
Not. But
13,
My lord, I here for the appellant, my lord. Hello, I assailed my lord, of the honorable single judge, my lord. The lordship at page 23, my lord. Start from page 23, my lord. The case in brief is that my lord, I was appointed as a Hindi teacher, my lord, senior grade, in a high school, my lord. In the 38/8/1992, then I obtained my graduate degree, B.Ed, my lord, in Hindi Parangat, my lord, which is equivalent to B.Ed, my lord. Then, my lord, by an order dated, my lord, 14/9/2021, at page 56 of the appeal memo, my lord, this higher school is upgraded to higher secondary school, my lord, without creation of any post of principal, whatever it is, my lord, with the existing staff, just only nomenclature was changed from high school to higher secondary school, my lord. So I was put in charge of as a headmaster of that particular Monachala High School, my lord. And thereafter, my lord, that order lordship will find that, my lord, page, my lord, 45, my lord. I'm sorry, my lord, not page, it is. My lord, at page 76, lordship. That is my first order, lordship, at page 76 of the appeal memo.
Yes.
In page 76, until further order, the appellant, my lord, I am so-and-so Parangat, Hindi teacher, so-and-so school, district Hailakandi is by allowed to hold the charge of a headmaster of the same school along with financial power to draw and disburse the salary, etc. of the staff of the school in addition to so-and-so, my lord. So I was a in charge headmaster, my lord. Then came this, my lord, the impugn order at page 77, my lord, which was put to challenge before the honorable single judge.
Yes.
It is on the sole ground that, my lord, the high school has been upgraded to higher secondary school. So therefore, my lord, it should be headed by a principal, my lord. So applying rule 12 of the Assam Higher Secondary Provincialization Rule of 2018, my lord, my order of 28/9/22 was cancelled, my lord. So that was put to challenge. The honorable single judge has concurred with that finding, my lord. My humble submission is this, your lordship, because since the school was upgraded without creation of any post of principal, my lord. So, lordship, there cannot be any question of in charge principal or regular principal, whatever it is, my lord. Because there should be a post, creation of the post first. Then, my lord, question of in charge regular will come, my lord. Even, my lord, under the Assam Budget Management and Fiscal Responsibility Act also, my lord, no post can be created, no appointment can be made, either as a in charge or as a regular, until the post is sanctioned and created with the concurrence of the Finance Department, my lord. And all other schools which have been similarly upgraded with that of my school, my lord, all headmasters are working as a headmasters are there, my lord. No principal has been appointed, my lord. And I have applied under the RTI Act recently, my lord. And lordship will find. I just place one, my lord. I flagged it, lordship, may kindly see. Lordship, I just, huh? I'm honest. Yes, please tell them. And they have declined, my lord. I just, lordship, I'll take my lord to that. The petitioner says so and so. I am originally appointed as Hindi teacher and the senior. I flagged my lord, flagged it, lordship.
Yes.
Here, my lord, last two lines, my lord. Lordship was that is the narration of the facts. Now, well, after narrating all the facts, if my lord look into last two lines, the post of the principal of Monachala higher secondary school has not yet been sanctioned. Whereas the headmaster of the school has been sanctioned, which is lying vacant so and so to till date, my lord. So post of principal has not been sanctioned. Therefore, my lord, by applying rule 12 of that 2018 rule, my lord post, which I am holding as a headmaster, my lord, till the post is created, sanction cannot be taken away, my lord. And recently, if your lordship, I, as a matter of my lord illustration, I have filed an additional affidavit also. In this case, my lord, in this case, just to bring to your lordship notice that similar situated all the high schools which have been upgraded along with me, my lord, they are all headmasters and holding the charge of the my lord. They are doing the function as a drawing, disbursing, whatever they are as a my lord, the headmaster, my lord. Not as a principal. No principal has been appointed as yet, my lord, because there are no sanction post. And as per Budget Management Act, unless a post is sanctioned and my lord created with the concurrence of the finance department, rule 12 cannot be applied. First, there should be a post, and only the rule will apply. Load cannot be applied in vacuum, my lord. If the post is created, principal is appointment, then I am out, my lord. That's my case, my lord. So let them have their stand, my lord, that our post of principal has they have been created all for the higher secondary school. Not my lord. So notice maybe go at this day. What I respectfully submit, my lord. Let them file their if it now this issue is an issue.
Yes, madam.
Tanya?
Yes, madam. Notice may go at this stage, and in fact, in the writ petition also, my lord, we have not filed our affidavit, my lord.
No.
Yeah,
No, notice has not been issued.
No, no, it is for admission only, my lord. Just instruction was sought for. Voice and in my humble understanding, subject to lordship's correction. It is an instruction later.
Notice was issued.
Issue of the mail. Then they may file allowed to file affidavit in this case. On that issue, not all other facts are admitted, my lord, by both this side, only on this issue, my lord.
Which issue?
My lord, only whether the post of principal has been created.
Regarding creation of the post.
Creation of principal, my lord.
Principal.
That will clear all the
In
issues.
the upgraded higher secondary school.
You
Upgrade.
take instructions and come back. What's the
Yes,
point?
yes.
That's BG Ghosh.
Yes, ma'am.
I'll put appellate. Mr.
NJ Khatania.
NJ Khatania, then
Yes, ma'am.
School Education Department shall take instructions as to whether the post of principal has been sanctioned and created in the which school?
Monachora High School, higher secondary school.
In the Monachera Higher Secondary School, Hailakandi.
Newly upgraded, my.
Based on
After 2 weeks, my lord.
after 2 weeks.
Again, whether lordship is convenient for a lordship to fix it is
Stop 23rd. 23rd of February.
of life lordship. Give reference.
Item 14.
In this case, we have to file an additional affidavit disclosing the status of the persons, my lord, as a social activist. My lord, we will be given 2 days time, my lord. You have prepared, but because of signature, for want of signature, we could not file, my lord. Only 2 days time.
Stay our Shikar, and it's also for the petitioner, it's not another 2 weeks time to file an additional affidavit.
Right. Develop.
Install 26th February,
My lord, on which day, my lord?
26th.
15.
Please, your lordship.
In this case, lordship, application file.
Hmm?
I may have to pay for admission hearing on day after tomorrow, lordship. No problem. Otherwise, everything. Otherwise, everything is ready, lordship.
Hmm?
Otherwise, everything is ready, lordship. 1 day, lordship.
15.5.
For admission hearing, lordship.
Yes.
My lord, it may be fixed on 15 to, my lord. 15 to.
Heard, Mr.
MJ Kadir.
MJ Kadir, learning counsel for the applicant, on request made by Mr.
As Bhuya, lordship.
S. Boyan, then a standing counsel.
Higher education.
Higher education, list on. You want it on 15th of February.
Oblige.
Item 16.
May it please your lordship. My lord, in this case, the petition, my lord, appellants before lordship were initially appointed as master workers, my lord.
Lordship, Deenat is in on leg, Lordship. Better we should pass the time.
What is it?
He is on leg, Lordship. Deenat, senior commander. Deenat,
Have you filed your affidavit?
Lordship.
They have not filed.
Okay, let him come.
Only thing, my lord, these appellants, my lord, they were initially appointed as master worker. They were regularized against personal post. Now this honorable court held in a separate case, my lord, that they are not entitled to promotion as they are appointed against personal post, but they are entitled to SCP and MSCP benefits. Now, if the lordship directs that benefits under SCP and MSCP scheme is given, their purpose will be served.
But then he has made a sense that you have been paid your SCP.
My instruction is that they have not been paid.
That's why let him come.
That if it is not paid, they can pay them.
Let him
If
come.
it is paid, then paid.
Item 18.
Actually, you should know whether you have got SCP or not.
My lord, my instruction is that whether they have not been paid the SCP.
There's a clear order that SCP time scale has been paid to you. And he has been asked.
By that observation, lordship may close this appeal also, my lord, that if it is not given, that can be given. By that observation also, this.
Let us, why don't you make sure whether you've got your SCP or not?
My instruction is that they have not received.
Then let Mr. Nath come.
And that is why, my lord, this honorable court, my lord, directed them, my lord, to file an affidavit.
Let him come.
My lord.
18.
May it please, your lordship. Lordship, in this matter, I had challenged the process of making appointment in Numoligarh Refinery Limited, lordship. After my challenge, lordship, they have come with a new proposal, but still I have some doubt, lordship. So they want to clarify my doubt, their officers, lordship. Instead of wasting the precious time of the court, they want to sit with me and have a discussion, then place it before the court, lordship. So we want some time, lordship. 2 weeks time may be granted.
Okay, on request made by the parties, list the matter after 2 weeks.
Much obliged.
19.
But in this case, the government is supposed to file their affidavit, my lord. They have taken time on several occasions. They are reluctant.
Lordship, Deenat is not present.
Do you have some instructions from Mr. Deenat? We always coming,
Yes,
he's not here.
Lordship, he asks us to take time for filing a affidavit, Lordship.
How much time?
These submissions have been made on.
Yes, I know. I have all the order sheets in front of me.
Yes.
How much time do you want?
2 weeks, Lordship.
Huh?
2 weeks, Lordship.
As a last chance. Part P. Burgastel and counsel for the petitioner. On request made on behalf of Mr. D. Nath, London Senior Government Advocate. I'll give him 3 weeks. 3 weeks. time.
Date will be given after 2.
As last chance to file contract. List on. March.
Item 20.
May it please your lordship. Lordship, this writ petition was directed against the notice by GMDA to demolish the wall of an apartment which was built by which was of the promoter of which was GMDA. If my lord may come to page 68, that is the prayer portion, my lord, from page 68 to 70. Prayer A, certiorari to quash the impugned show cause notice. This was issued by GMDA for demolition of the wall. B, also to set aside the order of demolition, so and so forth. My lord, this was on demolition of the wall. My lord, the picture of the existence of the wall, my lord will find at page 72, my lord. It was the approved plan of the Games Village. Games Village, my lord, was constructed under aegis of GMDA to initially house the officials and sportspersons of the national games. And later on, my lord, they were sold off to others, my lord, including
various government departments. My lord will find a road, my lord, which is the National Highway 37. Then there is one passage to Games Village, the blocks which lordship sees, that's the Games Village. Then, my lord, this is under phase 1. Then phase 2 and phase 2 is of, my lord, the second part, which would be built by GMDA later on. There is a brick wall, if lordship sees, towards the southernmost end. That is a brick wall which is written by hand. That was the brick wall under question. Now, my lord, the learned single judge held that we did not have permission for the wall and therefore did not interfere with the demolition. My lord, now a lot of time has passed since then, the wall has been demolished. We are not aggrieved by that, my lord, now, at the moment. What we are before lordships, my lord, if my lord comes to the impugned judgment from page 240, para 23 of the impugned judgment, which lordship will find at page 259. We are aggrieved by this para 23. In addition to the above, this court also finds it relevant to take note of clause 8 of the MOU dated 31st December 2014, wherefrom also nothing could be shown that the petitioner had authority to construct any wall. The only authority which is reserved for the petitioner society is for maintenance of the common facilities as well as partition walls, sewers, drains, pipes, and appurtenances thereto in good tenable condition in clause 4 of the MOU. In clause 8 of the MOU, which has been quoted herein above, it would show that the respondent number 2 still reserves the power to put up additional structures, flats, and other commercial buildings, facilities in the land shown as phase 2 area within the Games Village boundary, and also renovations, upgradations of facilities existing in phase 1 at its own cost. Therefore, as the power under clause 8 was reserved with respondent number 2 for renovations, upgradation of facilities existing in phase 1. There is also a clear stipulation in clause 8 that roads, drainage, sewerage, entrance, security, etc. of phase 1 shall be clubbed together with phase 2 if deemed necessary as per the assessment of respondent number 2, meaning thereby that the road in question upon which the unauthorized wall has been constructed can be clubbed by the GMDA with phase 2 project. The only exception to the use of the roads, drainage, sewerage, etc. was that the said road, drainage, sewerage, etc. cannot be used for construction activities to be carried out in respect of phase 2, that too when the same may affect the peace and tranquility amongst the residents of Games Village phase 1. My lord, here, this para 23, if I may humbly submit, the learned single judge went beyond the brief in my humble submission. Because the issue involved in the writ petition, my lord, was for as to whether the wall can be demolished or not demolished. This MOU which is referred to, though, my lord, we had approached under 226, so we had to annex the MOU. My lord knows when a flat is sold, an apartment is sold, under the Apartments Act as well, and as well as in the agreements, my lord, proportionate share of the land is sold to the purchaser, to the flat purchasers. The society which is formed amongst the flat owners, my lord, the society does not have any right over the land. The society can only manage the area. By this, a society cannot, a residence welfare society cannot enter into an MOU giving away right which it does not have. So in my humble submission, my lord, the society could not have entered into this MOU at that point, and especially when the society at that time was not an elected society. My humble submission, my lord, today before lordships, this is a matter which, in fact, there was also a appointment of an advocate commissioner because there were disputed questions of fact. My humble submission, my lord, the matter may be trashed out in the civil court. Only with the observation, my lord, that this para 23, or my lord may set aside para 23, and giving us liberty to approach the civil court. We'll approach the civil court, we'll agitate our rights there. But the learned civil court will not be influenced by any observation made by the learned single judge in respect of para 23. That is why we are before lordships. Because our rights, we need to establish our rights. The MOU was not in question, not in dispute before the single judge. And we simply referred to it because it's a court of equity. But my lord, that MOU cannot have any effect. We need to challenge that MOU as well. But my lord, that the proper court would be a civil court. So my humble prayer before Lordship is para 23 may be set aside since it was not the brief before the learned single judge, and we may be given the liberty to approach the civil court. The civil court will not be influenced by para 23. The brick wall which was demolished has against whose demolition we had come, that is already demolished. I'm not praying for any interim today, my lord, only with the liberty. That is my answer. Because, my lord, the rights of the flat owners, they do not go to the society. So the society cannot give away the rights of the flat owners.
Yes.
I would have agreed to this submission had it before the learned single judge. Now it is too late in the day to make this prayer. Whatever observation is made, it is on the basis of various materials before the learned single judge, number one, and various arguments placed before during the course of hearing. And then Advocates Commission was also appointed, Lordship. So all these factors, all these materials were taken into consideration while dismissing the writ petition and making the observations. There is no infirmity, illegality in the observations. Now they cannot go back because if they are not aggrieved by the wall, then what is the point of letting them go to the civil court now? So I have serious objections regarding this prayer. And if Lordship is pleased to dismiss the appeal at the threshold, Lordship may be pleased to do that. Otherwise, if notice is issued, we'll argue at length, Lordship, on this part.
Okay. Who appears you are appearing for, respondent?
I am for the GMDA.
GMDA.
2 and 3.
2,
3, 1, 2, 3.
1, 2, and 3.
1, 2, and 3.
And 4?
I appear for the issue now.
But he denied and the counsel for the appeal. Issue notice. Mr. D. Saikia, Leonard, Advocate General.
Yes, Lord.
Leonard, Advocate General Assam, appears for respondents 1, 2, and 3. And Mr. M. K. Chowdhury, Leonard, Senior Counsel, assisted by Mr. Ardas, appears for the respondent number 4. Stop. When do you want?
After 4 weeks, Lord.
Okay, list after 4 weeks.
May I pray for a date, my lord?
List on 11th March.
Lord. Highly obliged.
Deeply obliged.
Item 47.
May it please, your lordship. Well, this is a matter where through a summary procedure, substantive right of grade 4 employees whose services were terminated on the ground that the approval of the director or the finance approval were not there, that too after 12, 14 years of service. My lord, in a similar case, your lordship has already admitted the appeal, and has given an interim. My lord, we pray for the same prayer. In fact, this matter is also fixed for hearing. Well, absolutely no procedures under Article 311 of the Constitution has been given. A summer screening committee was constituted by the Health Department. Well, we occupy a substantive post. There has to be some semblance of procedure. There were many, round about 100.
How many appellants are here?
Lord, we are 15 numbers.
50.
Yes, 15.
15. Yes, heard Mr. D.K. Das. For the appellants.
It is.
Mr. D.B. Varad and standing counsel,
Health and Family.
Health and Family Welfare.
প্রথম ভুল করে
দরকার নাই।
All respondents?
Yes, my lord. On the
State on behalf of. Place the matter for hearing. When?
There it is shown.
It may be tagged with along.
Well, not, the tagging may not be taken because we stand on a different footing
Okay. list the
insofar as
matter
the
for
factual
hearing
part is.
After 4 weeks.
Bucky government order, this is.
My lord, if they are paying for the same order, my lord,
My lord,
so why it cannot be tagged,
On
my
the
lord?
hearing date, we'll make a submission. The
Then-
issues are same.
Then,
Whatever it is.
Yes.
Yes.
Well, the interim order which has been given for the 15,
Okay, till the next returnable dates. The
15
respondents are directed not to fill up 16 posts.
15 lots, 1-5.
15 posts held by the applicant, if still vacant.
Yes.
Stop, stop.
Obliged.
Item 21 for orders.
That's peruse the earlier order. The matter relates to Citizenship Amendment Act and some cases are pending before the apex court. That is why by earlier order, it was kept pending till decision made by the apex court.
Okay. So you want after some time?
Yes.
How much? 1 week or 1 month?
It may be 2 months.
Matter is pending since long, my lord. Actually, all the prayer have been fulfilled with the Union of India, probably except Citizenship Act, which is also the latest agreement with the.
The earlier order shows till decision made by this apex court.
But I am
the
representing NF
extent
Railway,
and
my lord.
zone.
Expansion of railway. Sufficient expansion has been done by the NF Railway in the northeast.
Okay, learned counsel for the party submits that similar matters are pending disposal before the Honorable Supreme Court. Stop. Accordingly, list this matter up for
2 months.
2 months. You want to go? Up for 5 minutes.
Officer said that the post, he can be accommodated accordingly, this honorable court directed. And the instruction was await from the respondents what they have done, what not.
Who appears?
Earlier, MS M. Bhattacharya was there. Additional senior government advocate.
Last time you took time to take instructions.
No, that actually they took time for taking instruction.
Yes, thus.
Item 22, court order decided directing the to consider. Item 22. 22, no? To consider. So, accordingly, it was placed to my knowledge. Now,
Can it be taken after some time, my lord? Just looking after by my DKS Sharma, my lord. I'll just inform him.
item 25.
May please, your lordship. No, this is with regard to construction of Silchar Harangajao Road by the NHAI. Lordship is monitoring this matter basically. It's a long run project, my lord. As per the latest affidavit, my lord, there is some progress made, my lord. They have, initially it was a bit slow, then they have started. From the last affidavit, the progress of the work, if your lordships kindly come page 146, 13.88%. Which was previously, my lord, 5.74% previous affidavit.
So this is,
My lord, it is done, we have already given in earlier two affidavits that this 2 lane will be completed by 31st March of 2024, my lord. As such, the jobs are going in full swing because day and night they are working. I have taken this one. And our assurance is already given by way of affidavit that is 31st March of 2024, the 2 lane will be completed. It's a progress. Then because this affidavit that as per Lordship's order, 2011, 20 November 2018, date was fixed on 19th of January, my lord. That as this case was that were not listed, it got delayed. We have filed up to 13 January, even the 13 January. Now the Lordship may, for our convenience, so that I can also put pressure on them, that may again maybe fixed on 1st March, first week of March, because though we are giving 31st March, my lord, one again it will be listed because job is going on full because it is national law because earlier we cannot compromise now in construction. That is the we are working full thing. And we are giving by way of affidavit also that it will be completed by 31st March of 2024. That's why if our Lordship kind enough, then it may be fixed again first week of March. Let us see the progress.
Is 13.88 is 2 lane or 4 lane?
There is a 2 lane. 2 lane is going on. We are giving from very beginning 2 lane on 2 lane. Now we are 2 lane we are doing. That
So
will
you
be-
have completed 13.88%.
Yeah, my lord. This whatever is progress it is there, 13% is completed. Now it will be completed, my lord. By 31st March, I have.
Standing Council, Guwahati High Court. The respondent number 2, Public NSCI, has filed an affidavit dated 19/1/2024, which indicates
Forget it.
that, which indicates that the 2 laning work of Jatinga-Aranga section within bracket package AS-21 is 13.88% complete. As on
And John, that is 13
January.
January of
13th
2024.
2024. So, to monitor the further progress, the NSCI is directed to file another progress report on or before the 29th of February 2021 or 2024. List the matter again on 1st March.
First, third, because I'll be out of station.
First, you're going out of station
Yeah, I may be because
on 4th March.
4th March. I'll apply.
Time for response number 39.
Mr.
R.K. Talukdar.
R.K. Talukdar, Leonard Council affairs for the respondent.
Response number 39.
And Mr.
She Sharma.
C. Sharma, Leonard Standing Council.
Imam.
Affairs for the Dima House Council.
Apply.
Deeply observed. Item 27.
This trial regarding implementation of section 12(1)(c) of RT Act. So we are preparing a cabinet memorandum, my lord, and the memo is being under process, my lord, and in the meantime, finance department have raised some queries, my lord. So we are replying to it. So my lord may grant some more time so that we can complete the cabinet memorandum and place it before the cabinet. My lord.
That was the submission made on the.
Yes,
last-
my lord.
last-
Yes. Yes.
In the process, my lord, finance department have raised some queries, my lord. We have to reply to that, my lord.
My lord, as per the activity calendar, lordship, next month, 15th of March of every year, unaided non-minority private school shall prepare the details. So if it's not yet being approved, then this coming scholastic year also will go, lordship.
No, my lord. As regards the coming academic season is concerned, my lord, we have offline process. We have already started, my lord. We have directed all the district offices, my lord. As regards the online process is concerned, my lord, that is under process.
So what is your submission to the?
My submission regarding offline, my lord, we have already directed the district offices to implement this.
So,
Take
no,
step.
no, you want to take time for what reason? On
Regarding my
what,
lord, cabinet memorandum, my lord.
what,
My lord, you give me
3 weeks time, my lord. First week of March, my lord, I'll.
You
If
said
required,
cabinet memorandum is prepared for placing before the cabinet on
Yes.
the last occasion.
yes, my lord. That was not completed, my lord, till date.
Third MSD goes.
Lordship, my humble submission will let it be fixed in this month only because then again, because from 15th March, it has to start, no, the activity calendar says that.
Mr. N.J. Katania, Learned Standing Council School Education Department submits that the cabinet memorandum is being prepared
Yes,
for placing before the cabinet and therefore press for 3 weeks time. Stop. Please, prayers allowed. List the matter on. We'll have it on 28th
Yes,
February.
27th, Lordship, 27th,
7th is a hearing day.
then 29th, Lordship, or on 26th, because 28th I have outstation case,
Okay,
Lordship.
29th.
Deeply obliged, Lordship.
Item 28. Lordship, in this case, Mr. R. Mazumdar appears, he filed an Akalandama, but his name has not been shown. Let it come next week showing his name, Lordship.
He's appearing for the,
Sole respondents, delay continuation matter, Lordship.
okay, heard B. Chakrabarty, Learned Counsel for the petitioner, for the appellant. Registry is directed to reflect the name of Mr. R. Majumdar, Learned Counsel, appearing for the sole respondent in the cause list. And list the matter after 1 week, after a week.
29.
Milord, it's regarding regularization process of a university lecturer, University Law College, Milord. I take your lordship straight to,
Why is it coming for orders today?
it should,
My lord, I'm appearing for Esplanade 1, my lord. In this matter, my lord.
It
So
should
far, my lord,
come-
notice has not been issued, my lord, to the remaining respondent. But
it should come as a admission heading, Milord.
so far, my lord, respondent number 2 is concerned, my lord. This is 3, my lord. This is Bar Council of India. This is necessary party, my lord.
Regularization process of a lecturer, Milord, University Law College. Case has not been admitted as yet, Milord.
No, notice has not been complete, I think.
Yeah, not issued, my lord.
Notice not issued. Notice has not been issued.
Milord.
Anybody appearing? You are appearing
I'm
for?
for Respondent 1, my lord.
Respondent number 1. How about respondents 2 to 5?
There are pro forma respondents, Milord. Notice may go, Milord.
Third PG Fukan and the conflict for the appellants. Issue notice. Mr.
A.K. Sharma.
A.K. Sharma and the council appears for the respondent number 1. Appellants to take steps for service of notice on respondent 2 to 5 by registered post AD
Yeah.
within 1 week.
Milord,
List after 4 weeks.
most of them.
30.
May I please, Lordship? Lordship, respondent 5 and 7 is awaited. There is a interim, Lordship. My humble submission is kindly may continue the interim, Lordship.
Lordship, in this regard, an affidavit has been filed on behalf of respondent number filed by respondent number 3 on behalf of respondent number 1, 2, and 3.
One that you are appealing for?
And for the Revenue Department, Your Lordship, respondent number 2. Affidavit has been filed by respondent number 3 on behalf of 1, 2, and 3, Your Lordship, regarding the disbursement of the compensation amount.
Have you taken steps on respondent file?
No, Lordship.
5 to 7?
The private respondents. Open the petition.
No.
No.
You take first steps.
Okay, Lordship will take a step. Lordship.
Let him take first.
Yes.
Mister, you're good now?
R. Islam on behalf of K. Vyas, Lordship.
R. Islam, then the council appearing on behalf of Mr. K. Boyan, praised for taking first step for servants of not yet on respondents 5 to 7. Stop. Praise allowed. Applicants to take steps for service of notice on respondent 5 to 7 by registered proceeding within 1 week.
Lordship.
List up to 4 weeks.
I'm up.
Obliged, Lordship.
Timing item 16.
But here, this signed affidavit I have received today. I'll serve this step.
Have you given the scheme,
Yes.
with the ACP?
Yes, yes, benefits will give it.
Yeah.
My instruction is that they have not received.
Okay,
But-
then let him file the affidavit.
Yes,
First,
yes,
I cycle
that
to
will
the
do.
council for the appellants. Mr. D. Linus, senior government advocate, submits that he is filing the affidavit,
I have received the copy today, filing today.
that he is filing an affidavit showing payment of ACP
Yes.
within bracket time scale.
Yeah.
To the 3 appellants within the course of the day.
Sure.
So, list the matter after 1 week.
1 week.
1 week.
But you fix a date, my lord, if possible, but
By that time, I think you should take your instructions.
my lord,
16th February.
my lord. Obliged, my lord.
Item 22.
For this.
Timing item 22.
Please, lord.
My lord, the case is related to appointment or compassionate ground.
Mm,
my lord.
mm.
We are awaiting, my lord, approval from the finance department. There is the instruction received. My lord, SLC has approved our appointment on compassionate ground, awaiting for the approval from the finance department. As per the office memorandum, we needs to take approval from the finance department. But in this case, my lord, finance is not hereded 30 respondent. That is the problem, my lord.
The departmentally will get it approval, my lord. We can wait for the next time, my lord. Because it is the duty of the department itself, my lord. And they will probably they have processed it. So let them obtain the approval, my lord. Otherwise, my lord, nothing will happen.
But
There-
Mr. B. Churchill, counsel for the appellant. Mr. D. K. Sharma, Leonard, additional senior government advocate. submits that the state level committee in its meeting held on 2nd March 2023 has recommended the case of the appellant for appointment on Senate grounds. And the respondents are awaiting the approval of the finance department. How much time?
If my learned been added, finance department, that will easier for us, matter,
Yes,
because
the
my lord,
matter-
they have my lord
No,
separate standing council.
After, list the matter after 3 weeks.
Public.
Lordship's small instruction may be fruitful, my lord, if your lordship's
I will
direct.
pursue, my lord, definitely will pursue with the finance.
You also take steps.
That,
Public.
probably he will pursue it. Again,
It's up to you.
yeah.
Item 31.
May I please your lordship?
Mm.
Lordship, the IA has been filed for condonation of a delay of 49 days, my lord. What has happened in this matter? The lordship had asked us to take steps by way of Dusty. We have taken, but the same was received by the brother of the respondent number 1. And as such, this honorable court had again asked us to take steps by way of Dusty, my lord. We have again taken steps, my lord, and we have filed affidavit. However, in this time, my lord, the respondent number 1 has refused to take notice, accept notice, my lord. Lordship will file the affidavit at page 11, my lord. Page 11, my lord.
No. You filed your affidavit when?
My lord, it was filed on 29/11/2023, my lord.
I'm on that. Well, this notice, he refused.
At page 13, my lord. However, the respondent number 1, Rupali Noor, had refused to accept notice by way of justice sent by this honorable court. And in this regard, the applicant has also informed the same by way of an entry before the in-charge Fulani police outpost, my lord. Notice is at page 16, my lord. Page 18 is the bus ticket, my lord. My engaged clerk had, my lord, traveled to Majuli along with the appellant to serve copy, my lord. And page 19 is the entry made before the officer in charge Fulani police outpost, my lord.
You should have taken someone as a witness and let the witness file the affidavit. Well, given undertaking that in my presence, so and so refused.
Lord, even his brother was on the earlier date, his brother has accepted, my lord.
We are not talking about
My
the
lord.
brother, we are talking about the second notice.
My lord, respondent number 7 has accompanied.
Appearing on behalf of respondent number 7. Mr. Deviram Tahu, he also accompanied along with the person, but she refused.
My lord, may peruse page 20, my lord. Deviram Tahu has signed, my lord. Narayan Nath, my lord.
Which page 20?
Page 20, my lord. Annexure C.
This page 25.
No, my lord. Page 20, my lord. Page 20 of the affidavit, my lord. Additional affidavit, my lord.
Annexure?
Annexure C, my lord.
Yours is what, page 25? It's page 25.
My lord, at the last portion, witness Narayan Nath Deviram Tahu, my lord.
Where's his signature? No, I'm having that. So let this Narayan Nath, who's this?
My lord, he's my clerk, my lord. Who has traveled to Majuli.
Diviram Dahu?
He is the respondent number 7, my lord.
Let him file an affidavit.
My lord.
Okay, my lord. They will pay.
Saying that he refused to accept in my presence.
My lord.
Then we'll see.
My lord.
I'm just adjourning it on your request.
My lord. Anyway, my lord, as per Order 5 Rule 15, my lord, since it was accepted by a male member, my lord.
Whatever it is,
My lord.
on request made by Mr.
R.B. Guha, my lord.
This is the matter after
My lord, on Friday, my lord.
on the 12th.
My lord.
By that time, we get your.
My lord, my
account
lord.
done.
God bless me.
32.
May please, Lord.
Yeah. Hello.
May it please your lordship. Lordship, I paid for 3 weeks time to file an affidavit.
My lord, in fact, in this case, I was directed to file a further affidavit to explain the delay for post-COVID. I have filed that. Now, my learned friend wants time to file a reply to this. My lord.
You want to reply to file? Okay. Where's your affidavit?
My lord, I have filed it on 30th of November, my lord, 2023.
Okay. But PK Royal and a counsel for the applicants. The applicants have filed an affidavit on 30 November 2023. In terms of this court's order dated 10/11/2023. Stop. Para. MS
JS Das.
JS Das, the counsel, appearing for the
For the respondent.
for sole respondent.
Yes.
So,
Sole respondent. Press for how much time?
Takes them.
3 weeks time to file reply to the affidavit filed by the applicants. Praise the Lord, list up to 3 weeks.
Highly authorized.
33.
May I please, your lordship? Lordship, this matter pertains to non-compliance of the directions of this honorable court passed earlier in PIL 55 2017. We have filed an IA, your lordship. And the directions in the PIL is there in our IA, your lordship. This is in regards to the functioning of the mental health review boards under the Mental Health Care Act 2017, your lordship. Your lordship takes up the IA that we have filed. The relevant portion of the order passed by this honorable court earlier, your lordship, is at page number 17. Lordship is there. If I may read from the second pair, I'll just take 2 minutes, your lordship. Mr. So-and-so learned counsel for the petitioners has submitted that the mental health review boards and the committees should start functioning as early as possible. And in order to ensure effective functioning of these mental health review boards and the committees, direction be issued to the respective chairman of the boards to submit reports to this court from time to time. Having considered the submissions of the learned counsel for the parties, and having gone through the affidavits on record, and more particularly, the additional affidavit dated 8/7/2022, it becomes clear that the state government has actively and effectively made attempts to implement the provisions of the Mental Health Act 1987, as well as the Mental Health Care Act 2017, and have already constituted mental health review boards and committees. As can be seen from the notification dated 30/10/2022, the respective committees have also been asked to formulate rules for effective implementation of the provisions of the aforesaid acts. We have been given to understand that state rules have also been framed in this regard. In light of the aforesaid development and considering the prayers made in the PIL, the respondent authorities are granted time till 31/3/2023 to complete the process and also to allot necessary budgetary provisions for the same so that the mental health review boards and committees start functioning effectively from 1/4/2023. So this was the first direction, your lordship, that it should start functioning from 1/4/2023, your lordship. Now 10 months have elapsed. Second direction, your lordship, It is further provided that each district mental health review board shall submit its report to this court through the chairman of Juvenile Justice Committee, and if any discrepancy is found, the same shall be brought to the notice of the respective boards for effective implementation of the provisions of the Act. In the light of the aforesaid, the prayers made in this PI necessary to be dealt with separately, as the provisions of the said acts are now to be implemented in its true letter and spirit. So, Lordship, what has happened, Your Lordship? Till now, Your Lordship, no budgetary provisions have been forwarded. They have submitted an affidavit in opposition, and we have submitted a reply, and we have filed RTI applications. They have set up 5 mental health review boards for cluster of districts, Your Lordship. But, Your Lordship, none of them have received any budgetary provisions. Now, the entire Mental Health Care Act, Your Lordship, the provisions of the Mental Health Care Act cannot be implemented until and unless, Your Lordship, the mental health review boards are functioning, Your Lordship. And Lordship, if I may, we have filed an affidavit in reply, Your Lordship, in the month of January, and we have asked certain questions, Your Lordship, because there is a state mental health review authority where the secretary of the health department is the de facto chairperson, Your Lordship. And the mental health review board, because these are quasi-judicial body under the Mental Health Care Act. But they are not functioning, Your Lordship, because no budgetary provisions have been made. So now what has happened, Your Lordship? Now any relief, Your Lordship, any mentally ill person, whether be in the prison or in other institutions, Your Lordship, if they have to avail the relief under the Mental Health Care Act, they have to approach the mental health review board, Your Lordship. So, Your Lordship, at this stage, Your Lordship, there was a direction passed that the mental health review boards may submit a report
No,
before
where's
this.
your IA? I'm not getting your IA.
I have filed it. It's 2366, Your Lordship, 2023. We filed the IA in PIL 55 2017. The order is at page 17, Your Lordship.
Yes.
And if Your Lordship, page 17, the last para, Your Lordship, the direction is mentioned. The respondent authorities are granted time till 31/3/2023 to complete the process and also to allot necessary budgetary provision for the same, so that the mental health review boards and committees start functioning effectively from 1/4/2023.
Yes.
My lord, we have filed an affidavit in the month of November. My lord, stating the current status as of November 2023, my lord. As of November 2023, my lord, 2 mental health review board meetings in 2 zones had taken place, my lord. My lord, we would like to file a reply, my lord, stating the current status, my lord, because in the meantime, my lord, development has taken place, my lord. And out of 5 zones, my lord,
The secretary should file a status report, Your Lordship, as well as the mental health review boards. They are already been notified.
You heard Mr.
V. Rajpal, Your Lordship.
V. Rajgaon and the counsel for the applicant. Stop. MS Arbor.
R. Barua, my lord. My lord, on behalf of Mr. D. Seke AG Assam, correspondence 1 to 7.
Of this Assam. Place for filing an additional affidavit.
Yes, my lord.
Bringing on record the status report
Yes, sir.
with regard to the
Functioning of the
Functioning of
mental
the
health
mental
review
health
boards.
functioning of the mental health review board. Stop. Where is allowed?
And
How much time?
My lord, 3 weeks time, my lord.
let's take.
Okay. This after 3 weeks.
Also, may I also pray that a direction may be issued to the mental health review boards. This is a direction was issued in the earlier order that a report may be submitted before this court. Because if the mental health review boards, Your Lordship, there are 5 of them now, they may be submitted, they also may submit a status report before
Let
this.
them come with the affidavit after
No.
that.
Yes, my lord.
Obliged, Lord.
34.
May I please, Lordship? It is an interlocutory application praying for delay of condonation 40 days, Lordship. So kindly, my humble prayer before your Lordship to issue notice, Lordship.
Anybody appearing?
Lordship for Industry Department.
Nayak,
Yes, Lordship. Respond number 3, Lordship.
Hmm?
Respond number 3, Finance Department.
you have four
Industry Department of
industries.
Respond number
2 and 4.
May appeal for 3, Lord.
Nayak for three.
Yes, Lord.
And one
I may,
and five.
5 is not there, Lord. 5.
Five is there. Managing Director Assam Power Loom Development Corporate.
In my petition, Lordship, there are only 4 responses.
Yes, how many respondents are there?
5, Lordship. 5.
IFL. Okay. Your
Five.
Lordship is taking the IA.
No,
But in the retapel, there are 4 only.
5, Lordship.
This serves to us, the retapel matter, only 4 respondents.
I want to type.
Retapel, there are only four.
Lordship.
You have any objection to the 40 days continuation?
No,
Okay. Heard, Mr.
B. Khaklari, Lordship.
B.
B. Khaklari.
Cutlery Leonard Council for the applicant. Stop. Also heard Mr. Endas
and
for the government advocate for respond number
1.
one. Mr.
and Kalita.
M. Kalita.
N.
N. Kalita, then a standing counsel
No, Lordship. On behalf of Mr. A. Kalita.
appearing on behalf of Mr. A. Kalita, then a standing counsel,
Yes, Lordship.
industry department. Four respondents, 2 and 4.
2 and 4.
And Mr. P. Nayak, then a standing counsel for the finance department. Oblique respond number 3. Stop. By this application, the applicant is praying for a continuation of 40 days delay in filing the connected to traffic. Stop. Learned counsel for the respondents have no objections. Or we have also considered the cost shown in the present application. And we are satisfied. Accordingly, delay of 40 days in filing the connected to traffic is combined. Registry is directed to register the retapel and Mr. Matrin is the usual course.
Give a bless, Lordship.
35.
May it please your lordship, I am appearing on behalf of SP Das. He is out of station due to some emergency. Lordship, it may be.
Inform me, let it be taken on Wednesday, madam.
If your lordship had admitted this, I, lordship, I have no objection, lordship. The present petition has been filed only for condonation of delay 46 days. So, lordship, Mr. May can be condoned and admitted. The retapel may can be admitted.
No, who appears for respondent 1?
I'm appearing for respondent number 1, Lord.
Apari Barma.
Yes.
And 2,
I'll be appearing.
3. You have any objections?
No, Lord.
No.
Yes, then.
Lordship, A. Alom, appearing on behalf of SP Das.
But Mr.
A. Alom,
A. Alam, learned counsel appearing on behalf of SP Das, learned counsel for the applicant. Stop. Hurt. Also hurt.
M. Soiker.
M. Saike, learned counsel for the respondent number 1. Comma, Mr. Endas, learned government advocate for respondent number 2. And MS? MS? On behalf of RK Talukdar and the standing counsel, accountant general for the respond number 3. By this application, the applicants are praying for delay of, for continuation of delay of 46 days in filing the collected writ appeal. Learned counsel for the opposite parties have no objections. We have also perused the course shown in the present application, and we are satisfied. According delay of 46 days in filing the connected writ appeal is condoned. EC is directed to register the writ appeal and list the matter in its usual course.
36.
May I please your lordship? Lordship, this interlocutory application has been filed for condonation of delay for 1469 days, lordship. Lordship, notice was issued on the last occasion, lordship, and accordingly they have filed an affidavit in opposition, lordship. Lordship, may kindly see the affidavit in opposition, lordship.
1 minute.
Can it be this taken up on my lord Wednesday? This was looking after when our borough. Because there is delay with regard to more than 1,000 days, my lord.
Otherwise, lordship, may kindly see the paragraph 2 of the affidavit, lordship, filed by them, lordship.
Wednesday, my lord.
They have stated, lordship, we have not given any proper explanation regarding the period from 2017 to 2018. But lordship, in the annexure, lordship will see, lordship, the petitioner is suffering.
Okay, if RV Bora is not there.
Had it been near about 100 days, that it would be different, my lord.
What's Mr.
N.K. Sharma, lordship.
N.K. Sharma, the counsel for the applicant. On request made on behalf of RV Bora, the government advocate. List the motion again on. When do you want?
My lord, Wednesday.
7.
Deeply obliged, lordship.
37.
My lord, item 37, I appear for respondent numbers 13 and 14. My lords, we have not been served with a copy of this particular application that they have filed.
Even
We are the project proponent, my lord.
the main case also, though court had directed them to take steps and ask for to the respondents to furnish affidavits. We have not been served extra copies also, man. This
You are paying for respondents?
My lords, 13 and 14, my lord.
13 and 14. This Nagal Pipra Bongaigon Transmission Limited, correct?
My
Have you served copy?
No, I'm for the respondent.
Oh.
And my lords, as per the last order, my lords had directed the matter to come after 4 weeks. So my lords, this application in my respectful submission is superfluous and my lords totally misconceived.
No, 1 minute.
The parent case, my lord, had issued notice and to be listed of 4 weeks.
No, what is this IA for?
In that case, my stay was refused. And with the same period of stay, my lord, relying on some Supreme Court orders, my lord, they have come with this IA.
Who appears?
Nobody.
AK does.
Power.
We'll list it some other day.
My lords will list it. We'll file a reply, my lords. We'll argue the matter. There's no problem, my lords. We'll place the submissions, my lord.
None appears for the applicants. Stop. Mr.
D.
Gugoi, then
Standing counsel to forest.
standing on the forest department appears for respondents.
Here, my lord, opposite parties. Well, it's 6, 8, 9, 10, 11, 12. Only 5. 6 and 7 for her.
5 and 7.
5 and 7. I'm for 6.
MS
MD Bora.
MD Bora, the government advocate appears for respondents.
5 and 7.
5 and 7. And Google.
I'm for my lords 6, 8, 9, 10, 11, 12.
11, 12. And Mr. Your good name, please.
My lord, CP Sharma, my lords, appearing for respondent number 13 and 14, my lord.
CP Sharma for the respondents.
I'm also for the 16, man.
Yes. After 1 week?
My lords, after 2 weeks, because we will have to file a reply to this application also, my lords, let them serve this copy.
All right.
Item 42 for hearing.
Deeply obliged, my lords.
May it please your lordship, I pray for adjournment for the time being, my lord. Mr. A.R. Bhuyan will appear. He is on leg in another court, my lord.
Let it be, my lord, fix some other day because they were directed to file an affidavit indicating certain issues, my lord. Lordship,
Yeah,
file-
in that case, my lord,
Next
next week. Yeah, that may be fixed then, my lord.
Next.
Okay, on request made on behalf of A.R. Bhuyan and the counsel for the appellants. Please turn. When do you want?
Next week, any day as per convenience of my lord. Oh, no? February 15. On my lord, 20, my lord. I'm sorry, my lord, in just check, 5. On 13, my lord.
13th.
Highly
Hold it.
applies.
43.
Yeah, well, I'm supposed to submit an instruction regarding presence of minutes of screening committee, my lord. So I have got the written instruction from the department that there was no minutes as such, my lord.
This matter, we've heard it before.
Hello, this is that case where a court directed by an interim order that the petitioners, if they are found working, they must be paid salary. That order your lordship will find 119. 119. One two zero, my lord. May I just read, my lord? From paragraph 2, my lord, the case projected by the petitioner is that after being selected in a recruitment process initiated in 97, the petitioner was appointed as an assistant teacher. So and so in the year 1999, the aforesaid school was under territorial of BTAD. Upon such appointment, the petitioner had been discharging her duties regularly. In the meantime, the petitioner was transferred to another school and subsequently by the order dated 2004, the services of the petitioner was attached to so-and-so school. The petitioner claims to be serving in the said school till date. However, the grievance of the petitioner is that though till the month of April 2006, her salaries were paid, thereafter no salary has been paid.
We'll take up.
A show cause notice dated 2006 was served upon the petitioner as to why her appointment should not be cancelled, to which the petitioner had replied. Thereafter,
Mr.
according to the
Nitin,
petition matter.
Today, it's going to be 1 o'clock, 5 minutes to 1. Okay, now, there's some engagement.
I was thinking, my lord, your lordship has heard the matter, only waiting for instruction. If I place one judgment, this will cover it, man.
Okay. No, we'll take up some more on a fixed date.
But if this bench, it will be very difficult for me to get the bench. My lord, only one page may I show, my lord. One page 215. Because fact is very clear that she is working and there was a direction that if she is found to be working, my lord, she has to be paid salary. So 215, your lordship may kindly note the Supreme Court order, one page order. It is very clear, my lord. Besides other, so many orders are there, one page order. This covers the case. Her appointment is still, my lord, standing. It has not been cancelled. More than 25 years. 215. May I just read, my lord? The single judge by order dated maintained the order dated so-and-so of cancellation of appointment of the appellant as principal on account of violation of chapter so-and-so. The appellant was appointed as a principal in the year 74-75 when junior high school was upgraded as high school and was recognized by the state government. Thus, the appellant has worked for more than almost 24 years before services came to be cancelled for the reason that he is a relative of the member of the selection committee. The order dated also records that the money be recovered from the appellant which has been paid to him as a result of his irregular appointment. We find that the High Court has failed to consider the fact that even if the appointment was irregular, the appellant had discharged the duties and in lieu of the duties he had to be paid. The state cannot take any work from any employee without payment of the salary. So court ultimately directed you, therefore, last paragraph, therefore we set aside the order so and so and direct the respondents to treat appellant as retired on so and to pay pensionary benefits if any due to him for the recent services. And then page, my lord, 217.
P.T. Das, today we have
Only my anxiety is that my lord pending for a very long time. Your lordship has- For further hearing. ma'am.
Due to paucity of that, it could not take it up. Okay, good. Next week you want?
Yes. For further hearing or?
No, not for that.
A form date maybe.
14?
14 is Saraswati Puja, my lord. So let it be on 16th or so.
13.
13, madam. 16, 15 or 16, my lord, any.
15.
Item 44.
Bad.
Your lordship, AR Bhuya is appearing for respond number 6. So he's on legs.
Third date maybe because it is pending for a long time. Third date maybe.
When do you want? Please stop.
Any short date. Third date, my lord.
When do you want?
Next week, any date, my lord.
Okay. 19.
Deeply obliged, my lord.
Item 1.
May I please, your lordships?
This is the other side.
Other side, I have not seen today. I have not seen her.
We'll list it on Wednesday then.
Wednesday, tomorrow.
Tomorrow.
If lordships.
Tomorrow there'll be some problem.
On lordships, Wednesday के तरह से lordships on 8 13 কি আছিলে on 15th lordships is available tied up later 15th
I don't know.
lordships
We can have it on 19th if you want.
19 or 20
Okay.
lordships.
But Mr. If you by way then it counsel for the review petition. Stop. None appears for the respondents. Public Union of India. List the matter again on 21 is.
Yes, last 20.
20. February, huh?